Good morning, counsel. Mr. Robinson, could I have you say something just to confirm that the judges can hear you?
Good morning. It's good to see you all.
Good morning.
Good to have you with us, Robinson.
Thank
Good morning.
I will ask that the courtroom deputy open court. Thank you.
The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning.
Good
Mr.
morning.
Robinson, are you there?
I'm here, Judge King. Good morning. May it
Yes,
please the
good morning.
court.
Our first case is Paluzzo versus Bayfield Loan Servicing. And Mr. Robinson, you're representing the appellant.
Correct, Your Honor.
You may proceed.
Thank you. May it please the court. My name is Philip Robinson. I'm here on behalf of appellant Ruben Palazzo. Mr. Palazzo is a former Chapter 13 borrower who had a long-standing dispute with the collection of his mortgage loan. In 2016, he commenced a bankruptcy proceeding to prevent the foreclosure of his home based on the disputed claims and sums claimed due by the appellees. And he successfully objected to their excessive proof of claim, which was materially reduced. However, following the proof of claim hearing, the appellees continued to seek categories of fees and sums from Mr. Palazzo that they were not entitled. They never.
All right, and what's your best evidence that appellees continue to collect fees from him?
They continued, the point, Your Honor, is they continued to attempt to collect.
Okay, even attempt. What's your best evidence that they even attempted to collect any debt?
First, they've admitted in discovery, Your Honor, that they sent payoff statements that sought sums.
And did he request didn't appellant request the payoff statements that they sent twice?
He did, Your Honor. And the payoff statements.
And they responded by sending it.
They responded by sending it and including.
And now somehow that's their fault.
Well, it's their fault, Your Honor, because the statements were inaccurate. Federal law does not permit inaccurate payoff statements. They're required, and we go through the briefing on this under the Truth in Lending Act since the Dodd-Frank Act. Those payoff statements were required to be accurate, and they conceded. So to go back to Your Honor's question, they conceded that those statements were not accurate and included monies the court had disallowed.
Wait, but my question, to go back to my question, was what is your best evidence that they attempted to collect a debt?
That a payoff statement, Your Honor, is an attempt to collect a debt when it asks for
The payoff statement was in response to, I thought you said the payoff statement was in response to appellant twice requesting that statement. And also, I think the payoff statement disclaims that it's attempting to collect any debt, doesn't it?
You're correct, Your Honor. And I'm assuming we'll get to the disclaimer issue. In addition to the payoff statements, which are required to be accurate, whether they're requested by a borrower or not, the appellees also sent periodic statements that identified fees and sums that they were not entitled to. Categories of those included foreclosure fees, attorney fees, and.
Okay, so I think I at least am at the disclaimer part of the argument now. What is your best evidence that all of those disclaimers and all of those documents, some of which were in bold, some of which were in all caps, were not effective to disclaim that they were collecting a debt?
Well, it's an excellent question, Your Honor, and this is the crux of the main issue in the case. We are not disputing that some statements, not all, had disclaimers. We are not disputing that there is case law that holds, as the court and the court knows and the parties have put before it, that holds that a disclaimer is an exception. Our argument is, the first argument, legal argument is, under both federal and state law, there is no exception for debt collection when there's a disclaimer.
But let me, Mr. Robertson, let me just ask the question because I think it bears on this. The Truth in Lending Act requires there to be periodic statements. And doesn't that go against you to some extent when you say statements are sent? The issue that Judge Thacker keeps bringing up, and I want to hone in on that because I think rather than just have an argument and we kind of already kind of figure out how we're going on that, I really want to hear your take on this because she goes to the heart of it. Is it an attempt to catch a debt, to collect a debt? Not a question of were there errors, were there inaccuracies on the statement, or were there things wrong with it, or they sent me these statements when, as I just pointed out, I think the Truth in Lending Act requires at least the periodic statements to be, and he requested the payoff statement. So that's a pretty powerful argument against your position here, don't you think?
On the surface, Judge Wynn, I agree that it sounds like a powerful argument, and there is some older case law that goes that way. The Lamerin case, which we cite in our opening brief, sort of addresses Your Honor's point, I think. It talks about, yes, the Truth in Lending Act requires the periodic statements. And in our opening brief, I think toward the end of the last section, I detail the statutory and the regulatory authority relating to what's included on a periodic statement. Nowhere in any of those statutory and regulatory requirements, though, are they inaccurate. And Lameron says, we see no, it ended on page 980 of that decision, we see no conflict in requiring the statements under the Truth in Lending Act to be truthful. So there is case law, more recent case law, I think, applying since Dodd-Frank, that the statements have to be accurate. And our point here is that those statements in and of themselves, to go back, I think, to Judge.
So let me interrupt just for a moment so I understand your point.
Sure.
If these statements that were issued were accurate, then you would not have a claim in your view. Is that correct?
That's correct. There wouldn't have been any.
So they can send a statement. Your problem is they must be accurate, even though, and maybe you can point me, I don't think those statements say anywhere up there that it's attempting to collect a debt.
Well, both the payoff statements and the periodic statements I kind of want to address together on that point. So they do have some of them, not all of them, have disclaimers. But they also have the periodic statements, for example, have payment coupons, pay these amounts, and they itemize what amounts are owed. The payoff statements say total amount to pay loan in full. The statements, both of them disclose in certain places, both categories, disclose in certain places that they're coming from debt collectors. So this is where I think you have to look at both the payoff statements and the periodic statements in total, not in isolation. Not one little disclaimer says controls the whole thing. And that's where the Daniels case, also from the 11th Circuit, so it's only persuasive in this court, just like Lamerin.
So let me bring up another point because I want you to address this too. I mean, this is not a Truth in Lending Act type claim, as I understand it. These are for an automatic stay and the Federal Debt Collection Protection Act. Is there something in those acts that require accuracy?
The truth, well, yes. Even though we're distinguishing and arguing that the court doesn't need to follow Lovegrove, in preparation for oral argument, I saw footnote 6, and although I suppose that's dicta, at footnote 6 in Lovegrove, it says, such communications, if they are in connection with the collection of a debt, must simply comply with the FDCPA. For example, they must not be false, deceptive, or misleading. So including information about foreclosure, including information about attorney fees that have never been approved by the bankruptcy court in the bankruptcy plan, we think that those are unfair and deceptive. And so they would trigger both the automatic stay and also the FDCPA and the state debt collection claims that flow.
Regardless of the disclaimers, is that what I heard you say earlier? That even though there are disclaimers, it doesn't matter based on your truth in lending argument?
Looking at it in the total, yes, Your Honor. I think.
Looking at it in the total, I heard you say a couple times that not all of these documents had disclaimers, but the two payoff statements that were requested by appellant, both of those contained the disclaimer language, didn't they?
They did, and I believe most of the periodic statements did. The two Form 1098s that for some unknown reason, baby.
The tax form? The tax form?
Correct. And
How
you're-
is a tax form an attempt by appellee to collect a debt from appellant?
Well, because, Your Honor, in viewing it in total, the whole circumstances here, going into bankruptcy, successfully objecting to a proof of claim, receiving statements that are demanding monies that are not owed, after this action commenced.
But with disclaimers, I mean, in looking at everything, I mean, I have to look at the disclaimers that maybe you can point me to one of these that did not contain a disclaimer. I haven't seen it. And also, don't we assume that doesn't our case law assume that appellant can and did read the documents?
There is, well, to answer the last question, Your Honor, there is some case law of the duty to read. I think it's generally described. And so, yes, but, and to go back to the prior question, I hadn't completed my answer on the Form 1098s. Looking at the totality of the circumstances, the 1098s didn't include, Your Honor, just tax information. They also included pages and pages in itemizations, and they're in the record, and we've cited them and highlighted them, of fees and sums that were not owed by Mr. Palazzo, but for some reason they sent them to him. Their answer under oath was they sent them to him as a courtesy. In the record, we provided another 1098 that the court is well aware of from its own personal experiences, and I am, that it included no such other fees and sums. So looking at it from the least sophisticated consumer perspective, with no disclaimers, we think those Form 1098s, including 43,000 and change and 133,000 and change for litigation fees, property inspection fees, foreclosure costs that were never authorized by the bankruptcy court, that gives the inference that
You're sort of skipping a couple steps when you talk about the least sophisticated consumer, though, aren't you? I mean, we have to find that it's false, misleading, or deceptive in violation of the act before we go to the viewpoint of the least sophisticated consumer, don't we?
I'm not sure the sequencing, and I don't disagree with Your Honor on the premise that you're providing, that you still have to find a violation of the act. And we think that we've cited a bunch of authorities from this court, the Coons case, the Guthrie case, which they don't respond to at all, so they essentially concede. And the Alexander.
Well, in the Coons case, isn't there a distinguishing factor there in as much as in Coons they actually did attempt to get a fee? It was not much, like $23 or something. Isn't that a distinguishing factor in Coons? Although I take your point with regard to Coons otherwise.
Well, I don't think that's distinguishing here when the attempt here was to collect thousands of dollars and they've conceded. Their managing agent for bankruptcy who had personal knowledge of it.
Mr. Robinson,
Yes, sir.
Coots, that's where you're hanging your hat?
Well, I believe, it's a good question, Your Honor. I believe Kuntz and Guthrie and Alexander control, because they're reported decisions, more than Lovegrove. The district court relied, and the appellees rely, and the appellees argue to this court that Lovegrove controls, but that was an unreported decision. I think
You say Lovegrove is distinguishable, or you say Lovegrove doesn't count because it's unpublished?
Well, I think we went through in our briefing, Your Honor, to distinguish it. It's a different fact pattern. Here we have a case that's not filed after the conclusion of a bankruptcy. This action was filed during the bankruptcy. And we identified Mr. Palazzo identified on his petition, pre-petition claims, which reverted to him. And then we also have post-petition claims that all arose during the bankruptcy. So it's a little different in that context. But I do think the reported decisions that discuss some of these issues, and Kuntz talks about the obligation for Mr. Palazzo continues in citing the Supreme Court case in Johnson, and we had cited that in our opening brief. And the Coons case does say that there's some disclaimers, but it sort of follows and parallels the Daniels decision that said sometimes a communication might have a dual purpose. Sometimes it might be for information, and sometimes it might also be for debt collection. Kuntz recognized an exception also in North Carolina law that if you're just providing an updated account summary, that's not then subject to the North Carolina Debt Collection Act. That exception doesn't exist here under either the FDCPA or the MCDCA, the Maryland Debt Collection Act. So I think Kuntz is pretty illustrative. I'm not arguing that any of these cases are on all fours. But I do think they're much more persuasive, and the reported decisions are sort of binding here. Any collection attempt, any act, the automatic stay claims rise and fall on any act. Here we've shown acts. In the Alexander case, defines and explains what the Supreme Court precedent and this court's precedent is on the definition of any. It's pretty broad. Same thing for FDCPA and the MCDCA. And we don't have a one-off where this happened just for a few days after that evidentiary hearing where their claim was denied and reduced. We have a situation where this has gone on for years, and it included not only these statements, but also to go back to I think Judge Stacker's comment on what other conduct is there. That Mr. Palazzo made a payment in October of 2022, I believe, was never given credit for it. His loan transferred to another from Bayview. He was never told about that from Bayview or the other until long after the fact. Bayview provided false information to the new servicer, RightPath. We detail all this in our brief. They had to roll off all the fees and charges that were transmitted when the loan transferred. And so we think that this is sort of on all fours. The ultimate question here, and I just have a few seconds left in my opening, is whether or not there was enough evidence for a reasonable jury to return a favorable verdict for Mr. Palazzo.
I can't really, I can't see the clock, so you're on the honor system. And I trust these lawyers.
Yeah, I think my time is all.
As long as you get questions from a judge, you answer them. But go ahead.
My time ran out in that statement, Your Honor.
Very good. You have some return.
Thank you.
Ms. Jefferson?
Good morning, Your Honors.
Good morning, Ms. Jefferson. Good to have you with us.
Good to be here, even if remotely. Thank you. Good morning. May it please the court. This appeal of the two district court orders, in our view, can be affirmed on three straightforward grounds. First, count one was forfeited by the appellant in his appeal brief. That's the appeal of the order on the contempt finding regarding section 1327. On counts 2 and 4, the challenged statements, debtor requested payoffs, and the form 1098 were informational, not acts to collect. I will be addressing the appeal of the first district court order, which covered counts 1 and 2, the bankruptcy code claims. My co-counsel, Brad Bernstein, will address the appeal of the second district court order covering count 4. Your Honors, to jump right into it, count 2 is the claim that the appellees violated the automatic stay by sending 3 categories of statements here. Those categories of statements are monthly statements, payoff statements, and the tax form 1098. And I think appellants fundamentally misunderstand how section 362 works. We heard in Mr. Robinson's opening argument that had the statements been accurate, there would not be a claim. That is, I think, conclusive of the argument on section 362 because the bankruptcy code draws no distinction between accuracy or inaccuracy. For purposes of the stay violation, the only question is whether it was an effort to collect, assess, or recover a claim that against the debtor that arose before the commencement of the case.
Fair enough, but let me ask the question regarding those monthly statements, because there are some oddities here in terms of what's being put forth. And that is, the monthly statement did have, I guess, before it went over to Bayview, it had a amount of 1450 on it, and then it changed to 1549 or so on the abatement statement. What was that about?
Well, Your Honor, the claim for the 1450 was a post-petition amount that Bayview ultimately wrote off. But for purposes of the automatic stay analysis, the fact that those are amounts that relate to
Well, let's assume these statements were for the for post-petition debts. We attempt to do that. Talk about our decision in Anderson.
Certainly, Your Honor. Well, if the amounts were all pre-petition, then it would still not be a stay violation for several reasons. First, the statements themselves all had very clear disclaimers. They also
well, Mr. Robinson said several times that not all of them had disclaimers. I thought they all did. What's your response to that? Maybe he can identify in rebuttal which ones did not have disclaimers.
I'm not aware of statements that didn't have disclaimers after the bankruptcy was filed. But I would also note.
Well, you didn't have one on the 1098, did you?
There was no disclaimer on the 1098, but the Form 1098 is a backward-looking annual statement that includes tax-related information that can't possibly be an attempt to collect a debt, because it's just reflective of amounts that were assessed in the past. And the First Circuit's decision in Henry Knowles clearly explains that a tax statement, a 1098, is an informative document sent in the normal course of business that contains data a debtor needs to prepare tax returns.
I think that's pretty much the general law on it, but I'll tell you something mighty odd about those attorney fees up there. Tell me about those attorney fees. I mean, they look like they would be pre-petition debts, and at least for the automatic stay, they must be pre-petition debts. But what are those fees about? It's almost as much as the loan on it when you look at it. It's a strange animal that you put at the bottom of that.
Well, Your Honor, conceding that we weren't counsel at the time, and so I can't speak with personal knowledge as to the fees themselves, what I can say is that presuming that those fees, for the sake of argument, were...
I'm trying to understand what that means. You weren't counsel at the time. I'm just asking about those fees up there. You're counsel on that statement now.
No, I understand. I meant that we didn't...
I want to know what those fees are. I just had never seen anything like that. That was strange at the bottom, and where'd it come from? It would scare the dickens out of just about any debtor out there that would see that at the bottom of a statement. 1098. Now, I grant the 1098. You know, I'm with you at the general basis of that. That's really it's really considered to be informational. But when you tack that at the end of it, at least it bears some, well, now that I have you before me, at least some kind of indication of why is it there?
So lenders...
What is it?
Yeah, lenders are required in a Form 1098 to report all fees that they incurred, and agreeing that the fees were large. As Mr. Robinson said, there was a long history of disputes between these parties, and whether or not those fees were being collected or sought to be collected against.
So you weren't the lawyer who got all that money there, I take it.
I was not,
And
Your
you
Honor.
think some lawyer was paid that amount of money for what has gone on in this case?
Your Honor, I
can't believe it. I mean, it sounds absurd to me.
I don't know whether those amounts were actually paid, but I would note that the district court made a factual finding that in each of the monthly statements, whether or not the categories of the fees were accurate, the total amount of the pre-petition arrearage, the $11,800 and some dollars, which is the amount that the bankruptcy court permitted by his order after the objection on the proof of claim, was never incorrect. The total amount of pre-petition arrearages was always accurate. And I would also point, Your Honors, for purposes of the automatic stay question, that the local bankruptcy rule is quite instructive in this case. In the bankruptcy courts for Maryland, there is a local rule. At the time that the district court entered its order, it was local rule 4001-5. It was since amended to 4001-6, but the language of the rule didn't change. And that language provides that creditors and lessors may continue to provide customary notices and correspondence, including monthly statements, payment coupons, escrow adjustment analyses, and tax statements to debtors.
Yes, I want to just ask just for maybe for clarity in terms of where you're going with that. And I get there's a local rule, but his claims arise statutory claims. He says that you are attempting to collect a debt, whether it's there or not is a question. Is there anything that a local rule can do to change that statute?
The local rule can't modify the statute, but federal courts under 28 U.S.C. section 2071 do have the authority to create and promulgate local rules as long as they don't conflict with federal statutes. And
That's the key. That's the key. As long as they don't conflict. His claims are clearly that this thing here says it's collecting a debt. And my question is, what can a local rule do that wouldn't conflict with that if in fact it is attempting to collect a debt?
Well, Your Honor, to the extent that the documents were an attempt to collect a pre-petition debt.
But the answer to my question, I know I'm baiting you into it, is really they can't do anything to change the tenor of the statute. That's really where I'm going. I wasn't trying to bait you into saying something there, but I think that's pretty clear. And I only went there because you want to go with these local rules, and I'm not sure how much of an impact they have, other than to give you some guidance on how they can do it and what they can do. But it's really the case law on the statute that controls here.
Yes, Your Honor. Local rules can't conflict with or modify a statute, although I don't believe there's been a challenge by Mr. Robin to the efficacy of the local rule. But I raise it to point out that the court itself provides guidance that there is good reason for lenders to be providing these statements, particularly in a Chapter 13 case, which I think we have to distinguish from a number of the cases that Mr. Robinson relies on that are Chapter 7 cases. In a Chapter 13 case where a debtor elects to make plan payments outside of a plan and retain property, the mortgage debt is not discharged. The pre-petition arrearage is, but they need information in order to continue making their payments going forward. And I'm out of time.
You've answered my question. Judge King said he can't see the clock, but I want to just let you know you answered mine, and I understand Judge Bernstein has 10 minutes, but I'll leave it to Judge King as to whether to go further.
Your time's up.
My time is up.
Mr. Bernstein?
Thank you, Your Honor, and may it please the court. I will be discussing the district court's decision as it relates to count 4 of the amended complaint, specifically whether there was an attempt to collect the debt under the Fair Debt Collection Practices Act. The district court's decision should be affirmed. The district court correctly determined on an undisputed record that there was no attempt to collect a debt. The district court applied this circuit's common sense inquiry standard and reviewed each document cited by Mr. Palazzo and determined that each document was informational and non-threatening, and all those documents, save for the 1098s, included a disclaimer that notified Mr. Palazzo that the statements were not an attempt to collect a debt and were for informational purposes only.
You know, it seems like the question here that Mr. Robertson's bringing up, maybe it's close or not, more on the mortgage statement than the rest of them, I would think. And in terms of whether it's an attempt, is it's the old duck thing. Is you can say it's not what it is, it's not an attempt or whatever, but if it's got figures and amounts up there and I don't know where that payoff statement, the 1098 form goes with those excessive fees from at least the fees that are indicated for the lawyers and what that means. But his point is, as I understand it, is it may not say directly this, but that's exactly what it's doing when it's putting up inaccurate figures there and fees on this statement. So how do you address that? It may be rather novel for us to even go in this direction because I'm not sure case has gone as far as what he's asking us to do, but at least the argument is worth discussing.
Well, that's a good question, Your Honor. And I think the district court acknowledged that just because a statement says it's not an attempt to collect a debt, that it could still be an attempt to collect a debt. And so the court looked at each document, the monthly statements and the payoff statements, and observed that there was no threatening language to pay a debt.
Focus on that mortgage statement, at least from my perspective.
Sure.
I'm pretty much there. I'm not there, I wouldn't say completely, but he asked for that payoff statement. And the 1098 is a whole different character, but there seems to be some closeness on the mortgage statement there that's in terms of what was there. So focus on that.
Sure. The district court found that, and I don't want to get into that the payoffs, the monthly statements did fall within the purview of the local bankruptcy rule. But found that the statements, when looking at the statements, not only did they include a very clear and
not to interrupt you there, but it's the local statement, but did the Truth in Lending Act require such a statement?
I don't know if the Truth in Lending Act requires, I think it does require a statement, but in Mr. Palazzo's bankruptcy plan, he was going to continue making his regular payments going forward to the lender. And so
but it would be, seems like to me it favors you quite a bit if the Truth in Lending Act, which it looks to me it does, requires that statements be sent, more so than a local rule. I mean, it seems to be a pretty powerful statement, but I'll leave it to you as to whether your interpretation is that it requires them or not. I just looked at it and thought, looks like to me the Truth in Lending Act required them to send those statements. Now the accuracy of it is another question, and maybe that's where it parcels out here. Does it have to be accurate? The question, at least from his perspective, that makes it an attempt to collect the debt, and that seems to be a little leap to me, but comment on that.
Sure, and I agree with Your Honor. It is a leap. The Truth in Lending Act requires that the monthly statements be accurate, and the monthly statements were accurate. But even if they were inaccurate, the monthly statements, the fact that they are inaccurate doesn't mean that the monthly statements were an attempt to collect a debt. And that is what Mr. Palazzo was alleging here, that the monthly statements along with the payoff statements were an attempt to collect a debt under the Fair Debt Collection Practices Act. A violation or a potential violation of the Truth in Lending Act doesn't transform it into a violation of the Fair Debt Collection Practices Act.
What about the Coons case? That does seem to have some similarities with the case here, as Mr. Robinson argues. It had a disclaimer as well.
Yes, and I think the Coons case can also be distinguished from the facts here. And the court, in its decision in Coons, addressed the differences between the facts in Coons and the facts in Lovegrove. For starters, unlike Coons, where the district court granted the lender's motion to dismiss, the governing legal standard here is not the same. Here, the district court granted our motion for summary judgment, as was the case in Lovegrove. Second, the letters at issue in Coons are significantly different than the letters that were sent to Mr. Palazzo. In the Coons case, while the letters indicated that they were not and should not be construed to be an attempt to collect a debt as to Mr. Coons's personal liability, they went on to state that they were a step in the enforcement of a mortgage lien against his property. Here, the letters said nothing about the mortgage lien surviving bankruptcy. They didn't mention foreclosure. but instead, like the case in Lovegrove, advised that they were for informational purposes only. In fact, the district court,
Like, case, don't you, Mr. Bernstein?
I'm sorry,
You like the case. You want us to follow that, right?
yes, Your Honor, I think the Lovegrove decision is on all
And you
fours.
You think Kuntz is distinguishable, but Kuntz is published and it's precedent. And
Kuntz-
Lovegrove is unpublished. It's not precedent.
That's correct, but I think there are factual differences.
You for that hurdle, and that's a pretty big hurdle.
Yes, Your Honor, I do agree, and there's no dispute that the Lovegrove case is unpublished and the Kuntz case is published, but we do believe that the Lovegrove case, as the district court found, was very persuasive, certainly more all square on the facts than at issue with Lovegrove. In fact, the district court found that the language in Bayview's monthly statements make the point more clearly than some of the communications in Lovegrove. The disclaimer
Is it an apples to apples comparison when, as I recall, Kuntz is a Chapter 7 liquidation case. This is a 13 bankruptcy where there's ongoing payments and that sort of thing on it. And, you know, bankruptcy always does cause us to pause and dig a little deeper on these things. But that seems to me to be the distinction when you're thinking about the tenor. I mean, the Kuntz case is somewhat different. It was a more aggressive way of collecting a debt, I think, for someone who was just making some ongoing payments in a Chapter 13 types thing. So does that make a distinction whether or not it's a Chapter 7 versus Chapter 13?
Your Honor, that's why I have my colleague, Ms. Jefferson, to talk about the differences between Chapter 7 and Chapter 13. I don't know if they really make a difference. I think the differences between Kuntz in this case is, in Kuntz, the Fourth Circuit was looking at it from a motion to dismiss standard. And the letters in Kuntz sort of went a bit further because they also said that they were a step in the enforcement of a mortgage lien against your property. And the beginning part of the Kuntz case, the court was talking about how foreclosing is a step in enforcement of, that it was a collection activity. Here, the letters that Bayview sent don't say anything about taking a next step or taking any action if you don't pay. And that's why the district court, when they looked at all of the statements, the monthly statements, the payoff statements, and the 1098 forms, they looked at it under the common sense inquiry and determined as a whole that the statements were informational based on the text, the context, as well as the disclaimers, and especially with the payoff quotes, that they were only provided based on the request from Mr. Palazzo, even more consideration to show that these were being sent to him simply for informational purposes and not in an attempt to collect a debt. I see my time is about up, so Your Honor, I'll just wrap up by saying that we request that the decision of the district court be affirmed. Thank you.
Very good, Mr. Bernstein. Thank you very much. Mr. Robinson, you save some time.
Yes, Your Honors. I pulled up one statement for illustrative purposes at JA 414. This one was from M&T. Within that statement, that Judge Thacker, that all of the periodic statements, to the best of my knowledge, included some form or another of a disclaimer. I want to be clear about that. I'm not arguing otherwise. However, they also sought, my argument is, other sums, and this statement is illustrative of that problem. In the transaction activity, which is supposed to be...
Okay, so I just want to make sure I understand what you just said. You do concede that all of these things contain some form of disclaimer, but your primary argument about them is that they were inaccurate. Is that correct?
And they also seek to collect. They do both things, Your Honor. They are in for informational purposes only. They have a disclaimer to that effect, but they also seek to collect at the same time. At JA 414, M&T provides Mr. Palazzo a periodic statement that itemizes foreclosure attorney fees. And as the Coons case held, foreclosure equals debt collection. Mr. Palazzo has a long history on this loan. They deposed him for a long time about a prior foreclosure and how that impacted him. That's what, from the least sophisticated consumer, he has a duty to read. He reads that, and you can see in the family testimony that's a JA 1529, 1554, which they don't dispute. They didn't depose any of those witnesses, how all of this affected Mr. Palazzo and created, emotional distress damage. I think Judge Wynn, you asked about the Truth in Lending Act requirement for periodic statements. I just want to be candid with the court. There was a period of time in the 2010s where the CFPB said the statements did not need to be sent to borrowers who were in bankruptcy. I don't believe that period of time covers the claims that are in this action. So you'll see some older cases that might address that. I just raised that in candor to the court. However,
Is there a private right of action for a Truth in Lending Act type claim?
against original creditors, the way the private right of action provision in TILA is written, you can bring an action against original creditors. So what the case law has developed in the Daniels case, the Lemonard case, and other cases, Tab, I think, Coons, Guthrie in this court, is that you use those violations of activities that might be conduct governed under Truth in Lending Act when they trip up the FDCPA, the MCDCA, and in this case, the automatic stay. I have a minute left. I want to address the two other issues raised by Ms. Jefferson. The local rules we did address in our reply brief at 10 and 11 and explained pretty clearly there why they do not control and they can't create an exception or a safe harbor for the defendants. And I think it wasn't cited in the papers, but just because I know it, the Zen Nails case addressed other local rules from the U.S. District Court recently and described some of that. The other, on the automatic stay claims, the automatic stay applies, the relationship here between the appellees and Mr. Palazzo was pre-petition. It's a mortgage relationship that arose pre-petition. All of the efforts to collect, whether it was pre or post petition, in this case, all arise or fall from that pre-petition mortgage relationship. And we think pretty clearly, we've cited all the case law, that this sort of conduct is governed by the automatic stay. And with that, we'd ask the court to reverse, and I appreciate the court's indulgence in allowing us to do remote argument and for the clerk's assistant in setting this up.
Thank you very much, Mr. Robinson. We appreciate your arguments as well as those of your colleagues, Ms. Jefferson and Mr. Bernstein. We'll take the matter under advisement.
Thank you, Your Honors.
Madam Clerk, we need a period of time to arrange for the second case. What's the process here?
Yes, sir, Judge King. Let me just get the other lawyers situated. Give me just one moment and I'll let you know when you're ready to proceed.
Very good. Thank you very much.
Judge Wynn, we're ready whenever you're ready to come back.
All right, I'm back.
Let me rearrange you and then we'll be ready to proceed. Hold on one second. Judge King, we're ready to proceed whenever you're ready.
I'm right here, Madam Clerk.
Judge King, we're ready to proceed in 25-13-15.
Yes, ma'am.
Thank you.
Mr. Magistro,
Yes, Your Honor.
good to have you with us, Mr. Magistro.
Good to be here.
You may proceed.
Thank you, Judge King, and may it please the court. I'm Anthony Magistro, and I represent the Tedricks, an ordinary couple trying to get a little bit ahead by paying extra on their mortgage every month. In this case, Loan Care seeks to rewrite both the text of the West Virginia Consumer Act and the parties' contracts. It seeks to add a separate check requirement, a requirement that prepayments be made by check to the note, even though the note grants borrowers the right to prepay principal at any time without imposing that condition. And below, it sought to add an intent requirement to the remedial statutory provisions of the WVCCPA that prohibit any unauthorized charges and any false representation of the amount of the debt, effectively reading the word any out of the statute. By adding these conditions to the contractual text, the parties did not agree to, and by narrowing prohibitions the legislature deliberately wrote broadly, Loan Care and the court below depart from settled principles of textual interpretation. Because neither the WVCCPA nor the note in this case supports those revisions, reversals required. In sum, this is an easy case. We apply the plain meaning of the
And
words that are
there
in the
aren't
statute.
any West Virginia Supreme Court cases that address this, are there?
There are a bunch of issues here. I'm not
The issue about whether the statute requires intent or not.
I don't think there's anything exactly on point. There are other cases that talk about how
I'm wondering if it's worthwhile certifying this to this particular question to the West Virginia Supreme Court of Appeals.
Well, we would not object to that if that's what the court wants to do. That's always your discretion. It would be 3 out of my last 4 if you did that. I think they're getting tired of hearing from me that way, but I'm always happy to argue in front of both courts. But I think there's a reason you don't have to in this case, and that is that in this case, in spite of they've made this argument below 3 times. First 2 times the district court denied it. The 3rd time they got the district court to bite, and the court dismissed the case on summary judgment. Then on appeal, they completely abandoned that error that they invited the district court to make. I think this court's precedents are clear. They don't even discuss it in their brief. They, in fact, almost make fun of us. They and make the argument that we're changing the subject for arguing that what the district court actually ruled on was incorrect. That's clearly not the case. We had our entire opening brief dedicated to that argument, and the response is, well, you're just changing the subject. This court's precedents, I'll cite Mayfield versus NASCAR in 2012, said, when a party's failure to raise or discuss an issue in its brief, that's deemed an abandonment of that issue. So because they've abandoned the issue, I think you can rule on it yourself and reverse just on that basis alone.
You've got some assistance here from the Attorney General, do you not?
Yes, on the underlying WVCCPA claim, both the West Virginia Attorney General through the Solicitor General, and we also had amicus briefs from national consumer rights organizations. So there isn't anybody in this case that says the WVCCPA, or at least in this appeal, that says the WVCCPA requires intent. And we would, and so I think that's pretty clear. And I guess I would take some direction from the court at this point. I can address that argument in detail.
Well, before you go there, let me make sure you said there's no one in the case. I thought the district court said that.
Well, I think that is in this appeal, and I
understand that.
I stand
he's kind of in
corrected.
this appeal. He's kind of in this appeal. You're reviewing his order. He's the one that right now. That's the state of this case, is that it requires intent. And I think if we're going to look at that, Judge Thacker was pointing that direction. I think you're right. It is either a simple case or straightforward. I think your position, this is a strict liability statute. Is that right?
Exactly. And
so the question that comes to mind is, and Judge Thacker went there, is has the state court said that? directly. And I think you're right. There's a lot that indicate that's the case. But the comfort level of being able to say that a statute is a strict liability statute, when it has false representation, I mean, I don't know how you unintentionally do something false, but I mean, well, I guess it could be misleading or that sort of stuff. But we're parsing out a lot of language type information, but the answer comes from the statute. And so then the question is there, well, let me ask another question since I've rambled on about that. But the question I really want to ask is there anything in that note and the deed of trust that are unambiguous with regard to the proper application of the advance payments? And if so, then do we get to look at the Fannie Mae guidelines?
Okay, so I think that's two questions. The first question is
do just that question. The other one, I kind of think it's just out there. Something it's going to be in your presentation.
So I'll go to the question. So first of all, the note in the deed of trust expressly adopt West Virginia law, which say unambiguous terms must be applied as written, and any ambiguity in an adhesion contract like this should be construed against the drafter. Fannie Mae is not the drafter. They're not a party. They're not even a regulator. The note doesn't say we should interpret this contract based on the Fannie Mae guidelines. So none of that is that's and that would be bad policy to say that that you and I can enter into a contract and then some third party gets to reinterpret that contract, amend it. These guidelines change. They're not static. They change over time. That is not contract law. Contract law is you and I make a deal. We write the words we agree to in the contract, and in this case, those words are unambiguous. They say that there is a right to make a early payment of principal at any time. And that's what these plaintiffs did. They have some conditions. The condition is you can't be late on your payments. If you're not making a prepayment of principal, if you owe other fees, you haven't made your payments. But in this case, my clients made every payment on time and paid extra. There's also another requirement, and that is that you separately state that it's a prepayment. That was done here. In fact, that was done both on the checks my clients wrote and on the payment coupon form that Loan Care sent. There's a space on the form that has a blank that says prepayment of extra principal, and they filled in every month what they intended to do. So they met the clear prerequisites of the contract to make that prepayment. Now, and Loan Care then was obligated to credit that prepayment based on the clear provisions of the note, and there's similar provisions in the deed that allow that prepayment at any time. They couldn't wait and credit that payment later. Does that answer your question, Your Honor?
It does. What is the amount of money we're talking about? That's the differential that makes up this.
So in this case, they had gone through several servicers. One of their earlier servicers did it correctly, and so this is the same note, but GMAC was an earlier servicer, did it correctly.
What's the bottom line figure? What are we talking about?
So they refinanced, and at the time of refinance, our expert calculated it was $155.56 worth of interest difference. Not $1 million, but not de minimis either. It meant a lot to them.
Are you telling me that this arises from a differential that if they had done this correctly, they would have saved $156?
Yes, sir.
Well, why wouldn't a bank just give them $156?
I don't know.
That's Mr. Killing. I looked at it and I was trying to figure that out. I got it from your perspective. I mean, this potentially is a class action. Could be all kinds of other stuff to go with it. The practices are there. But from a practical standpoint, I mean, even for someone to sue for it is amazing to me that if the difference is $156, and it's no doubt, it is impressive that your clients, in terms of the way they sought to pay off this debt. It reminds me, not to ramble on, but when I did real estate many years ago, real estate law, practice law, there were certain types. The older ones wanted to pay off the debt. Young folks just wanted to know how much it was per month. And so that's kind of what they remind me of, that generation that wants to pay off the note and burn the note. And that was their intent here. But But you're telling me it all comes down, and it's rather fastidious, to $156. Well, yeah,
And Your Honor,
I know it's about more than that from your perspective, but not from the banks. I can't see that. I mean,
and let me tell you that lets me go back to the underlying substantive claims, the underlying act claims, because the act deals with this situation in three different places. It gives rather than make me show intent, it gives them three outs. The first out is if they figure it before I sue, and I have to give them notice before I sue, they can just refund the money, and that totally removes them of any liability for for a penalty. The second thing is I have to send that notice of right to cure, and they can make a cure offer. And the consequences of making that cure offer, if they come back and said, we're going to pay you $156, then I would likely be barred from collecting any attorney fees if we turned that down and we didn't get more when we went to trial. And the third defense is the good faith error defense. And that is if they show something is a mistake, or a mistake of fact, or let me get to my notes on that.
But the point you're making, I've got those three things, and that's a real good. But just answer this question. Are you telling me that at some point in time, when this all started out, a demand was sent says I overpaid by $156, and the bank wouldn't just give the $156? They'd rather just be sued for it.
Well, it happened two different ways. First,
it's one thing to say just say you don't know what the interest, don't know what it is, but did you make a specific demand for like $156?
So I don't know if we had it calculated at the point. So what I do know is prior to hiring counsel, Mrs. Tedrick regularly called Loan Care and said, I don't think you're doing this right. She complained about it. Unsophisticated woman. That's when she hired lawyers when they wouldn't fix it. To calculate
she sounded pretty sophisticated to me to figure out this right here. This is not an ordinary thing you can figure out. That's pretty.
I think she knew what she knew is something was wrong. She couldn't figure out exactly what was wrong, and they were doing it differently than the other servicers had done it. And then we had then we sent the right to cure. They're sophisticated enough to calculate what that was. They could have come back and made an offer. Heck, they could have come back and made an offer of $1,000. I imagine we're burning up way more than that just being here today. But they didn't do any of that, and that is one of the reasons why they're not entitled to the bona fide error defense, because they don't claim this is unintentional. They think they're right, and they're not. I think on the act. Go ahead, Judge.
Let me ask you, the certification thing. You kind of got past that. But what weight, if any, does the Attorney General's opinion get in West Virginia?
I think traditionally the courts in this state have given weight to the opinions of the Attorney General. The Attorney General by statute is permitted to give opinions, formal opinions when asked. He doesn't really have a dog in the hunt other than to give opinions as to what the statute is. But I think the statute is.
Would his brief as amicus here in this case be equivalent to an opinion of the Attorney General?
I don't think technically. I think it is certainly the Attorney General's opinion, and I think it's pretty.
The Attorney General is on. His name is on this brief that I have here, this green brief, and he supports your position.
Yes, and I point out is that it's rare that the Attorney General files amicus briefs in private civil cases. They've got a lot of stuff to do.
not an opinion of the Supreme Court.
No,
of Appeals.
I think it's persuasive, and I think what I would, before you all decide to certify the question, what I would ask you to do is go back and look at our brief where we explain that intent is required in certain provisions of the statute expressly. In the provisions at issue in this case, intent is not required. They are trying to add intent to that statute. Now there are Supreme Court cases that we've cited that says that is not the way you interpret this remedial statute. You don't add words that aren't there, and words like any. There are cases that we cited. Any means any, and that the Supreme Court is very clear on. And I think I'm out of time. When I see questions, I'm out right now.
Any other questions? You've answered questions if you get them.
No further
No, I don't
questions.
have
Andy.
any.
Very good. Thank you, Mr. Magester, and you saved
Thank
some
you, Your
time. Mr. Killian?
Good morning, Your Honors. May it please the court. I guess I propose to look at both halves of this argument. First, talk about intent, and secondly, to talk about payment application. The Teterics have tried to make this appeal about that intent issue. And I want to be very clear that that portion of Judge Jackson's decision is, in our perspective, at most an alternative holding, one that we did not argue for below and that we are not defend here. My friend on the other side has suggested that we urge the district court to reach that decision, but I would point the court specifically to page 18 of our summary judgment reply brief, where we said, quote, loan care does not represent that plaintiffs prove intentional conduct as a claim element. That has not been a part of our case, and we don't defend that issue here.
Okay, so you're
Judge Stafford
discounting the entire argument that starts at page JA 876 of your memorandum in support of your summary judgment, where you do talk about Rice and Perrine and reasonable interpretations versus.
So Judge Stacker, I'm sorry, I don't mean to talk over you. The internet gives me a little bit of trouble sometimes. No, for Rice and Perrine, our position was that in those two cases, other judges had found payment misapplication, but then concluded that that still didn't violate the West Virginia CCPA. Our case, our argument has always been that this is an a fortiori situation. We don't even have payment misapplication. So how could there be a violation of the West Virginia CCPA? So to put differently, we've tried to argue consistently that the fundamental issue in this case is the issue that the Teterics presented in their complaint, which is whether we applied their extra principal payments correctly. That's what we sought summary judgment on, and that's the main issue that I wanted to defend today. So I guess I just want to clarify, though, Judge Stacker, to use my friend's metaphor, we don't have a dog in the hunt on the intent question. So for that reason, we would not.
You're throwing Judge Jackson overboard.
We would point the court to the other alternative holding in Judge Jackson's decision. I think they're
coming to Richmond and abandoning.
Judge King, there are portions decision below that we did not press for and that we don't defend here. There is a portion of the decision below, though, that we did press for and that we do strongly defend here.
I still don't really understand how you're saying you didn't press for it. The district court followed Perrine and Rice, and those are the two cases that you briefed pretty thoroughly in your memorandum in support of the motion for summary judgment. So were Perrine and Rice decided correctly then in your view?
Rice and Perrine, in our view, both involved a case of payment misapplication. And so they moved to the second question of whether there was a violation of the act, even where there's payment misapplication. And what we tried to contend
regardless
is that
of intent or not?
I think that's sort of weaving through those decisions, Your Honor. But yes, it is not the intent question that would be presented in the affirmative defense, for example, of whether something was mistake or whether it was an accident. For instance, I'd say Rice.
So in your view, in Appellee's view, does the statute require intent?
We have not taken a position on that, Your Honor.
Well, can you do that now?
can we do that now?
Does
Take a
the-
position?
One way or the other, does the
Yeah.
statute require intent or not?
I think the particular provisions that are at issue here make that actually a difficult question. As Judge Wynn was alluding in his question, as I understood Judge Wynn's questions, I don't mean to attribute this to him. There is, I would say some potential ambiguity between the prefatory language in section 127, which refers to fraudulent and deceptive conduct, and then some of the itemized violations, which don't refer to intent. I think, in other words, that this is when a case where this issue is presented, it is an open and potentially difficult question. Our amicus, for example, has said that they believe
Well,
that
then,
this is.
is this a remedial statute in your view?
I think that's right, but I think the question of text is the primary question. And so given that, Your Honor, I'll come back to it, but to say we have not taken a position, and I don't know that I'm going to take one today for the court, because we don't think that that's the issue in this case. We have tried to argue this case, continual payment application, and that's.
Do you agree that the district court's opinion indicated that it ruled in your favor, in part at least, because the district court believed there was an intent element to that statute?
I think in part, the district court did suggest that, yes.
And
But
so that's
then-
why, you don't necessarily agree with that. So you are discounting that or throwing the district court overboard, as Judge King would say, and redirecting our attention to what's your alternative argument?
Sure. To pages 12 and
Trying to
13.
get to, I'm sorry.
No, it's fine. To the very end of the judge's opinion, pages 12 and 13, where the judge addresses what we thought to be the real issue in this case, which is whether Loan Care applied their payments correctly. That is the question that they pleaded in their complaint.
So all that other stuff that the district court said before the very end of pages 12 and 13, that's just
An
dicta?
alternative holding. I would put it in the category of alternative holding, Judge Thacker, that he ruled on two grounds that are independent of one another. He addressed intent, and when he talked about whether Loan Care meant to get it wrong, but then he turned and looked to whether Loan Care in fact got it wrong. And on page.
What do we do with it?
What do you do with it, Your Honor? I would suggest that the court, if the court has concerns with that portion of the opinion, and from the indications today, I'm gonna make a guess that that's true. I would say that the court could acknowledge that that question is not presented in this case, that it remains an open question, and then that it could be fully litigated in a case where it's, parties are adversarial on that issue in the future where the issue is squarely presented. But for reasons that I was trying to get into in response with Judge Thacker, we think the issue could potentially be more complicated. I understand sort of the weight of authority, and certainly the opinion of the State Attorney General are strong indications about what the right answer may be under West Virginia law. But generally speaking, our position is the court should not reach out to resolve an open question of state law unless that question is squarely presented.
So on that question, you would be advocating, sounds like to me, a certification. But let me ask you this question. Are you saying that even if we assume that this is a strict liability statute, you're saying factually, your argument is that factually it was not violated?
That's correct, Judge Wynn. And I want to point out, though, I don't suggest certification at all, because I think certification sort of kicks the can down the road on an issue where there really is no adversity between the
Well,
parties.
from your perspective, it wouldn't matter, because either way,
Correct.
you're saying you didn't do it. I mean, so it to some extent, if I'm reading it, it's kind of difficult to follow, because so much below was on this intent issue. The trial judge was there, and the briefs have gone there, and I get the point you're making. I think it's pretty strong that the intent element is just not there. The question then is if it's a strict liability statute, and it seems like I thought that would answer the question if it goes one way or the other on that. But yours turned more on the factual determination of, did you factually violate this statute based upon, I guess, the deed of trust in the note and in the payment of the interest here? So
That's exactly right, Judge Wynn. That's how we tried to present the case, I think, in summary judgment below. And we think Judge Jackson got to that in the end of his decision. And I would point the courts very specifically to the paragraph, I believe it's JA 2755. It might be 54 to 55, depending on the
So
carryover.
wait, let me make sure I understand this, because I think this is really critical. It does sound like we're kind of, you know, how you study something, you think you got it down, and you come in and then the arguments. I want to respect your perspective on this. That is different. But where is it that the district court made a determination that there were misapplied, that there were not either not or were misapplied payments under the terms of those mortgage documents? In other words, where did he really get to the factual part, that part you claiming he got to?
So that's the page I was pointing the court toward. So if I could sort of move to that portion of my segment, the argument. So the way this
Isn't that
case
your whole
came,
argument, though?
oh, it sure
I
is,
mean,
yeah.
yeah. I mean, you say you were getting to it, but I mean, that's you weren't just moving to it. You were already there. That's your whole argument, from what I understand, is that, you know, the district court determined that there wasn't a misalignment of payments. I mean,
Right.
So there's
On
nothing to
page-
move to. You're already there.
All right, then. Then
Yeah,
let
what
me pick up.
page is it
uh,
of the
it's-
district courts?
It's page 12 and 13 of the slip op that we have, which I think is 2755 or so. The Judge Jackson takes the theory of payment misapplication that the Tetrix pleaded in their complaint. Because, right, that's what you do with summary judgment. You take the theory in the complaint and you see whether it survived discovery. And the theory that they presented was that when they made these extra principal payments, which were combined payments along with their regular monthly payment, that those payments were supposed to be applied first to extra principal and second to the monthly payment, that there is a proper sequence according to the Tetrix. In their complaint, Judge Thacker, it's paragraphs 19, 27, and 30, where they specifically plead that order of operations. And what Judge Jackson identified, I'll happily go through the evidence of detail with the court here, but on page 13 of his decision, he looked at those and said that the Tetrix payments, quote, fit squarely into the Fannie Mae guideline that requires a payment first to the monthly payment and then to the principal. There's a table, we reproduced it in our brief. It's in Fannie Mae guideline F-1-09. It says if an extra principal payment is made along with the monthly payment, you do it in the way I just described. And if it's made separately, then you do it in the way that the Tetrix had thought that this case was originally about. But the problem, Your Honor, is that during discovery, it came to light that the Tetrix theory of payment misapplication was simply incorrect. And in fact, at summary judgment, when we put forth our statements of undisputed material fact, the Tetrix did not even respond to the key facts, which are facts numbers 81 through 92 in our summary judgment brief. The way it operates in this court is that the movement, puts forth a statement of undisputed material fact, and then it's up to the opponent to respond. On those 11 or 12 undisputed material facts, they did not respond. They admitted all of those facts. And what those facts show, Your Honor, is that all of the Tetrix extra principal payments, every single one, because the evidence came forth in discovery, was made as a combined payment, including the regular monthly payment along with the extra principal, whatever it was in a particular month. And if you look at the guidelines, the note, and the deed of trust, and I guess I just want to emphasize, Your Honors, because Mr. Majestro has tried vigorously to run away from the guidelines, but the guidelines were one of the three legs of the stool in the complaint that they pleaded, specifically paragraph 16, 17, 18 of their second amended complaint, paragraph 67 of that complaint. They alleged that all three of those documents, the guidelines, the note, and the deed of trust, pointed to a single payment application, which was extra principal first, then monthly payment. And so we think Judge Jackson looked at the guideline because the guideline was the clearest of the three, which says they're wrong. But in addition to that, their note and their deed of trust also require the payment application process that Loan Care did. Paragraph 4 of the note, which is on page 403 of the joint appendix, defines a prepayment as a payment of principal only. And as this court recognized in the Flores case, which is an unpublished decision, so we're not sort of citing it as binding on the court, but simply as a recognition of the plain meaning of those terms, that a payment of principal only means a payment of only principal. But a combined payment.
So that I'm fair to you, and again, I understand the difficulties of litigating, and when a judge is sort of thinking something and you're talking, his head is kind of there. I want to let you know where I am on this, and you address this, because I think the district court fully, not just in part, based this decision on this fact that this West Virginia Consumer Credit Protection Act requires intent. I don't think it ever determined whether the payments were misapplied. And so this part of the decision that you're talking about, the district court had already defined false representation as a fraudulent act. So based on that definition, which is downstream of the court's holding, that this act requires intent, he said the appellant did not engage in false representation. So it seems to me that's what the district court held, and what you are arguing is what you probably wish he had gone to instead of focusing on that. So address that, if you will. Help to clean my mind up on that, if you will, because I'm kind of stuck on that right now.
Okay, so I mean, the meat of this analysis on the paragraph that spans 12 to 13 is absolutely a focus on the type of payments, the way they are made, and how they are applied under the Fannie Mae guideline. And thus, as he says at the top of page 13, the TEDRIC's 180 payments, which is what this case is about, fit squarely into this category, namely the category where the servicer, quote, must apply the scheduled payment first, then apply the curtailment. And of our position, the conclusion that he draws from this, which is the factual theory, the exact opposite, really, of the factual theory that the TEDRICs had pleaded in their complaint, it's a totally warranted conclusion then for the judge to say, how could there be a false representation or unfair or unconscionable conduct when the theory of payment misapplication that the TEDRICs pleaded simply didn't survive discovery? But Judge Wayne, to get even more pointed to your question, if Your Honor doesn't agree that that's in fact what Judge Jackson did, I guess I would just remind the court that at summary judgment, this court reviews judgments, not opinions. And so while there may be portions of this opinion that misstate West Virginia law, the court exercises de novo review. And it is, we think, not an appropriate situation for the appellee who did not encourage that error and who does not defend that error.
Well, the good news for you is we don't have to, I don't have to do this while you're making this argument right now, because his order is right there. And we would definitely compare where you have gone with this, with his order. And if it moves me from where I am, certainly I'm going to do that. That's the good news. That's being an appellate court. We're not an English system where you're going to get an answer right now on it. You've given me something to reflect on, and I'm going to reflect on that in light of the way this order is written. It almost, I guess, should say, parse it out and really get down to the meat of what this case is about. So, but thank you for advancing that.
But to finish my point, Judge Wayne, if I may, it's simply not whether Judge Jackson misstated West Virginia law, and if this court wants to clean that up, if it wants to say nothing about it, I mean, ultimately, that of course is the panel's prerogative. But
you know, when he got to the end of it, he just said he really recognized you made an effort to comply with the Fannie Mae servicing guidelines. And in that effort, intent is not needed.
and the very same reasons that we complied with the Fannie Mae guidelines are the exact same reasons why the payment application was correct under the note and under the deed of trust. And so again, the court doesn't review opinions, it reviews judgments. That factual assertion, which, I mean, to be clear, at summary judgment, we believe that was a characterization of the undisputed evidence, it fully takes care of all of the payment misapplication theories. I'll quickly rattle those off because paragraph 4 of the note defines a prepayment as a payment of principal only. And these combined payments, because they included the monthly payment, a portion of which includes interest, along with the extra principal, by definition, are not prepayments with a capital P. They're not a prepayment. And the note, and the trust, paragraph 2, which also provides for an order of operations for applying payments, applies to all payments and says you apply first to the interest and last to the
Right.
principal.
So in
the
understanding your argument you're making now, and in defense of the district court, the district court went the way it did, I believe, in its opinion, because that's how you briefed it. At least I'm looking again at your memorandum in support of appellee's motion for summary judgment. So where in your summary judgment briefing should I really focus on to, as Judge Wynn pointed out, understand the argument you're making now?
Yeah, so Judge Thacker, we went through in the first half of that full summary judgment brief are the statements of undisputed material fact, right? And as I was saying, the court needs to compare our statements.
And then you launch right into Rice and
argument
Perrine
one is Rice
and a
and
discussion
Perrine.
of those.
And then the following arguments are that
page
the
2.
payments were applied correctly. I don't have that brief in front of me right now, Judge Thacker, but the conclusion of that argument was
Okay,
that,
I guess my point is just that we will, of course, review it all, but I think the district court went the way it did because you briefed it the way you did. That's just one opinion.
Judge King, my time's up, but may I respond to Judge Thacker's point and then before I close?
Absolutely. And if you get other questions, we'll respond to those too. Go ahead.
Thank you, Your Honor. Judge Thacker, insofar as there was ambiguity in our opening brief, we tried to put that to rest in our summary judgment reply brief. And as I cited to the court, reply brief, page 18, JA 2069, we said, and I quote, "Loan care does not represent that plaintiffs must prove intentional conduct as a claim element." So,
You're
so
right, you
Judge
did
Thacker,
say that earlier. I
we
appreciate that.
put that directly to
2069?
Judge. Correct. We put that directly to him before he issued his decision. So if there was a misstatement or a misunderstanding about what we meant by Rice and Perrine, we tried to clear that up on reply and tried to reorient this case to where we thought it had always been oriented, which is that the payments were applied correctly under the note, under the deed of trust, and under the Fannie Mae guidelines. As Mrs. Tedder herself.
Why didn't you go back to him after he filed the opinion?
Well, Judge King, we won after that opinion, and as I said, I think we believe.
You come up here and then throw him overboard.
Judge King, we did not come up here voluntarily. As appellee, we were brought up here. We are making the same arguments that I think we have consistently made from summary judgment forward. I guess to answer that question, Judge King, our position is that there are alternative holdings in that opinion. And while the first one we don't defend, we absolutely defend the conduct-focused concluding portion of that decision. And so for that reason, regardless of what Judge Jackson said about intent, the independent finding that our payments, quote, fit squarely within the guidelines is a sufficient basis for this court to affirm, and we ask the court to do that.
Thank you very much, Mr. Killian.
Thank you.
Mr. Magistro?
Yes, Your Honor. Can you hear me?
Yes.
Okay. So it should not surprise anyone that Judge Jackson ruled the way he did. This was not isolated citations of Rice and Perrine. They made this motion 3 separate times. Now, they did argue the other alternative. They did it right, but they pressed this argument. In fact, in the final opinion, Judge Jackson says it is the central issue in the case. That's how he refers to the intent issue, as the central issue in the case. So there's no question that's what was the ruling. Now, in other parts of the case, he assumes that the payments were made correctly or incorrectly, and then reaches the intent argument. At the end, he has this statement, as Judge Wynn points out, what he's saying is you complied with the guidelines. You didn't do anything intentionally wrong. That's what his holding essentially is in that. And even if he is ruling that they win because they complied with the guidelines, that decision in and of itself is error, because third-party guidelines to which my clients were never a party, which can change at any time, cannot bind these parties in terms of contractual interpretation. Especially in an adhesion contract with West Virginia law, which this contract explicitly makes applicable, requires you to construe against the drafter, which are the defendants in this case. So regardless of whether he's ruling based on the guidelines, that's just wrong. Next response is Flores. Flores did not involve somebody who was making full payments and an early payment at the same time. They were paying half of what they owed. If they would have been doing it with the same deed and note here, there would be no obligation to credit it, because the notes and the deeds say credit first to the payment that's due. Our client made the payment that's due. That is undisputed on this record. What he's saying is that the note that defines prepayment as a payment of principal only. I would say, again, that's ambiguous when you make the payment of principal along with a full payment, especially when you make that on a coupon that is provided by the defendants. Again, look in the record. They sent this coupon that says how much for prepayment. They didn't say, if you're going to make a prepayment, make a separate check. The only reason to make a prepayment is to reduce your principal balance so you pay interest. So construing the contract against the drafters, again, I would suggest that my clients, even under that tortured analysis of what a prepayment is, we still win. Finally, and let's go back to the case law. I'm happy that I have associates who remind me of things. And my associate reminded me on the question of has the Supreme Court ruled on this, that there's the case of LTD Financial. That is we cited it's a 2019 memorandum decision. In that case, involved one of the statutory provisions here, Section 128. And what the court said was explicitly, let me find. Petitioner's argument in support of its first assignment of error turns on an assumption that intent was a necessary element for a respondent to establish his case in chief, and that because he failed to do so, the circuit court erred in ruling in respondent's favor. We do not agree, as the plain language of West Virginia Code 46A2 128E does not require proof of intent. That's pretty clear. And it's consistent with all of the court's analysis that we've cited as to this remedial statute. Any means any. It's a strict liability statute. We think that the Supreme Court,
that really does not. I mean, if I'm understanding your opponent's argument, that doesn't matter from this perspective, because he complied with it. That's really where he's going.
And I think the answer is
either way.
They did not comply with it because the note allows them to make a prepayment of principal at any time. And that is not that. And they want to read this. You have to do a separate check. They want to add that language into the contract where it's not there. When you fully paid up and you make a prepayment, that is a prepayment of principal that you're allowed to make under the explicit terms at any time.
Anything else?
I'm out of time, and unless any of the other judges have questions, thank you, Your Honor. We'd ask that you to reverse the judgment and remand it for further proceedings.
Thank you very much, Mr. Magistro. Mr. Killian, we'll take the matter under advisement and adjourn court for the day. Good to have you all.
Thank you, Your Honor.
Thank you.
This honorable court stands adjourned